Hi and welcome, and thank you very much for joining me today. What's going to be what I would like to call a masterclass on estate planning. My name's Tony Ashbolt and I'm the Managing Director of Connaught Corporate Solutions, and for 35 years now I've been helping clients just like you to make sure that they do the right things when they're looking to protect their family, your family home, your investments, cash, a business if you have one, and how you can control your inheritance taxes, and another little nasty one that the revenue like to throw in on death, which is probate. All right, so that's some of the stuff we're going to cover today. I'm also going to cover urban myths. Urban myths about whether you are a common law husband and wife, if you die without a will, and that's what we call intestacy, if you have godparents, if you have a joint bank account, and property ownership, because there's a right way to own a property and there's a wrong way. I'm also going to tell you some stories, okay, that are going to help you. Some of these will sit with you because the situations, these are real life stories, and they'll sit with you and they'll help you to understand what's important about your own situation and your own planning. And also, I want to give you my book. Now, my book is on sale at Amazon, and you can buy it for $29.99, and it's going to be available in most good bookstores shortly. However, today I want to make sure that you get a copy for free, and I'm going to tell you about how you get that right at the end. To get the book, there's a sort of 10-question survey to see whether you qualify or actually whether you need one. And that survey form's available here, and I'll make sure that my backup team make that available to you throughout the video. All right, is that okay? Good. So let's get started. This is what the book looks like to start off with. It's called Passed On. Information you need to pass on before you pass on. In here I talk about when you go on holiday and the things that you do before you go away for 2 weeks in the sun. If you've got young children and you're just having a nice romantic break, you make sure that somebody's looking after your kids. You make sure someone's looking after your pets. You maybe phone the bank and say, listen, we're going to Florida for a couple of weeks, or we're going to Thailand. If there's any unusual transactions on my bank account through Thailand or Florida, make sure they go through, because obviously we're trying to enjoy ourselves out there. You'll tell the neighbours that you're going away. Maybe you'll give someone a key to come in, let them water the plants. You're going to tell various people that you're away, this, that and the other. Now, that's great, and you do that for 2 weeks while you're going away. You put all that preparation together. Now, think about if something terrible happened while you were away and you never came back. And think about all the information you know about yourself, about your finances, that you haven't actually told anybody where anything is. My book is here as a record to help you keep all that information in one place. Now, you can have the book as a hard copy, and you can get that from Amazon, and there'll be a link for you to get it if you want a hard copy. We've also created it as a digital copy. Now, the digital copy will be sent to you upon application straight to your inbox. You can print it off once you've got that if you want to. You can store it as a digital format, which means you can look at it on your PC. Because it's editable, you can keep updating. Because if you think about your life, what happens throughout your life, there are things changing all the time. You change jobs, you buy new properties, you have more children, people come and go, and all this information needs to be recorded in the book. Your PIN numbers, your passwords, your social media. This is all in the book. I'm going to show you how to get that at the very end. Now, let's talk about estate planning. Now, what I mean by estate planning is the best way for you to pass your stuff, the things that you own, to the people that you love. Now, there is one urban myth that people think, well, don't worry, I'm married and everything will go to my wife. If you don't have a will, you're in for a shock, because guess what? The government has written a will for you. Now, I'm going to read something ad verbatim so you can absolutely hear what's in store for your family if you've got very basic planning in place or no planning at all. And just to let you know, 2/3 of you in the UK have zero planning in place. The other third who've got planning in place, 90% of it is inefficient or incorrect. So basically, it doesn't do what you want it to do. All right, so just bear with me for a second. Right, I'm going to read this out. So, for those people who've died intestate, and this is with no will, the government has written a standard will which will almost certainly contradict the wishes that you would have wanted to have happened. And this is how it reads. To my family, I hereby leave you all several months, possibly years, of financial hardship and expense, whilst you go to unnecessary lengths to sort out my affairs. To my spouse/partner, I hereby leave you some, but probably not all, of what I own. To my children, I hereby leave you the remainder of my estate and give you the authority to enforce the sale of any part of it, including the family home, to realise your inheritance. To social services, if my children are orphaned, I give you the authority and of guardianship and the power to choose who shall look after them, including allocating them to foster parents. To the taxman, I hereby leave you all the tax that I could have avoided and given to my family. To my bank/solicitor, I hereby authorise you to charge whatever you feel necessary to sort out the mess I've left behind. I realise that this could make you one of the major beneficiaries of my estate. To everyone else, I leave you nothing. Now, that's pretty powerful, because you're all sitting there thinking everything's going to go to who you want, and you're absolutely wrong, because it's definitely not. Now, there are three prongs to a good estate planning setup. One is a carefully drafted will. Two is putting assets that you own into something called a trust, or a variety of different trusts. And three is having and making sure that you have what we call lasting powers of attorney in place. Just to come back to a trust, for those of you who don't know what a trust is, the simplest way to look at it, a trust is a box. And on top of the box is a set of instructions. And the instructions say who can open the box and what they can do with what's inside the box. And the box has obviously got a keyhole, and it's got who can open it, who's got the keys. All right. So what we're now going to move on to is talking about real day life applications of what can happen and what can go wrong if you don't have the right plans in place. Okay. Right, what we're going to cover now is property ownership. There's three ways you can own a property as an individual in the United Kingdom. You can own it on your own, so solely. You can own it jointly with your partner, with your husband, with your wife. And you can also own it jointly with your husband, wife/partner as a term called tenants in common. So there is a right way to do this and there's a wrong way. Now I'm going to show you the wrong way from a planning point of view. So let me just give you the example. So for this instance, we've got a married couple. Okay, so here's the husband, and we're going to call him Gary because that's his name. And he's married to his long-term sweetheart, Jenny. Gary's 42, Jenny's 36. They have 2 children. Okay, the children are Daisy, who's 8, and they've got Jack, who's 6. So Gary and Jenny, they own their house. This is what their house looks like. Okay, and they own it jointly. That's what they bought when they bought their home. That's what their advisor and their solicitors told them how to buy it. Now let's tell you what can happen in the real world. Unfortunately, one day on his way home from work, Gary is involved in a car accident and is pronounced dead at the scene. So in the eyes of the law, because Gary and Jenny own their property jointly, Jenny now owns the property 100%. This is now sitting in her estate 100%. Okay. Gary and Jenny, they just had basic wills, right? We call them in our industry, basic wills are what we call mirror wills, which means on death, anything that the husband owned goes to the wife, and on her death, anything that the wife owned goes to the husband. So most of the wills that we see that are done, that's how they're set up, which is rubbish. And I'm going to show you why. So, unfortunately, Gary has passed away. Now, after a period of grace, and for this instance, we'll just say a couple of weeks, Jenny, a young lady, decides she wants to get back out into the world and start living her life again. Because she's only 36, she's a young woman. So she decides that she's going to take up tennis. So she pops down to her local tennis club and signs up for some lessons. Her tennis coach is a young Spaniard called Juan, and he's a good looking lad. He's kind of like 6'2", dark swarthy features, designer stubble, beautiful haircut, and his body is ripped as you would imagine this tennis coach would be, lovely tan, and he looks great in all his whites. So Jenny starts having some lessons with Juan, and over a 6-week period she's having 2-3 lessons a week, and Jenny starts to take a bit of a shine to Juan, and Juan, who we'll just put him up here. Juan, he's only 30. He's a single lad, but he's taken a shine to Jenny, and so much so that at the end of their 10th lesson he says, Jenny, do you fancy getting a coffee in the clubhouse? So they do, they sit there and they have a coffee and they're chatting, and they realise that they like each other. So then Juan plucks up the courage and invites her for a drink the following week. They go for a drink and they have a great time. Jenny, for the first time in a long time, has taken the trouble to get herself together, put a bit of makeup on, dress up nicely, and she was really looking forward to the date. They go out on the date and they have a great time. That drink then leads to Juan asking her out for dinner a couple of days later, which she goes. They go to the cinema, they go to the theatre, they go for walks, and they end up, as you can imagine, they end up having a weekend away at a nice country hotel. The next thing you know, Juan's got his Slazenger rackets in the hall at Jenny's house, and he stays over more and more, and he becomes a permanent fixture. And after a little period of time, Juan pops the question, and Sally says yes. So now Jenny says to Juan, they've got married, listen, we need to put our financial affairs in order. We're going to do exactly what me and Gary did. So Juan and Jenny rewrite their wills, and guess what they do? They do exactly the same as what Gary and Jenny had done. Now, Juan, 6 years younger than Jenny, and after a period of time, they've had a fantastic marriage. Unfortunately, Jenny becomes very ill and dies. The home in Jenny's will now leaves that 100% to Juan. Juan now owns the family home. And he decides that actually he's heartbroken and he's going to return to home. So he sells the home because that's what he can do, and he returns back to Madrid. Daisy and Jack get nothing, absolutely zero, from their parents' estate, because this is how their parents had arranged their affairs. Okay? So if you're sitting there in your lounge, on the bus, on the way to work, watching this, and you don't know how you own your property, now is the time to find out. So put that on the list of things that you need to be concerned about. If you have these wills, these mirror wills, now is the time to be concerned. If you have young children, now is the time to be concerned. So, make a note of that. We're now going to go on to the next section, which is stepchildren. Can I have a cloth, please? Because I need to clean the board. Thank you. Right. We're now going to talk about stepchildren. It's a thing of society now that there are so many divorces. From 2015, of the people that got married in 2015, 42% of those marriages have already ended in divorce. And you're probably sitting here watching this, whether you're in the car, the train, or whatever. You may be in a second or a third time round marriage, and you may have stepchildren. Now, I'm going to tell you a story now about a couple that got married. Now, this was second time round. Here's the husband. His name's Mark. And his second wife was a girl called Gemma. Okay. From a previous marriage, Mark had two boys. These boys are now in their 30s. One's called Bruce and the other's called Wayne. That's me kicking the bucket. People are dying to get involved with this. Anyway, so we've got Bruce and Wayne, who are the sons. Guess what? These boys, 32 and 34, they don't like Gemma, their stepmum. Anyway, let's tell you about the setup. Now, Mark owns his property outright, okay, in his name, and Mark and Gemma have no wills between them, nothing. Now, obviously, something has to happen for there to be a triggering of a problem, and unfortunately, Mark dies prematurely. The house, and we'll call the house for this example, a house is worth £650,000, and that's all that Mark has to his name. There's nothing else. There's no cash, there's no life insurance, there's no pensions. It's just the house. Law of intestacy now kicks in, and this is where you see what happens. So the first £270,000 of Mark's estate goes to Gemma. The balance, which is taking that from that, which is 380,000, is now split between Gemma, Bruce and Wayne, which means Gemma gets another 190,000 and the boys get 95,000 each. That is what would happen in this instance. Now, because Bruce and Wayne don't like Gemma, if you remember what I said at the start of this presentation, children can enforce the sale of an asset, particularly a family home, to realise their inheritance. Now, unfortunately, these boys are a little bit short-sighted, and this is what they do. They enforce the sale for Gemma to sell the home. So Gemma ends up with the first 270 from the proceeds of the sale and another 190. So she walks away with 460,000, and the boys walk away with £95,000 each, which is a little bit short-sighted, because if they'd have hung around, they could have ended up with all of it. And also now what's happened is Gemma is not living in this type of house that she was used to, because she's had to trade down. She's lost a third of the value. Not what Mark would have wanted. What Mark should have done, he should have written a will, and in his will stated that Gemma had a right to reside in the property until she passed away, and then on her death the property was to be sold and the proceeds split between the boys, and they would have ended up with £325,000 each, less some taxes, which is far better than £95,000 each. So if you're sitting there and you've got stepchildren, or you're sitting there and you own your property on your own without a will, this is a massive problem. All right, so that's the end of this story. We're now going to move on to something which is another penal tax called probate. Cloth, please. Okay, I'm just going to clean this off and then we'll get on to the next bit. Right, we're now going to talk about probate. This is a process that when you've passed on, your executors have to go through to prove ownership and to make sure that the assets pass to the right people. It used to be, and it still is, that solicitors work in conjunction with the executors of your will, whether you've made one or not. They'll work out every asset that you own personally, and they will charge an amount of money to the estate to do that. Now that can ramp up significantly if you have a large estate, and most solicitors will work on a time cost basis for some of their time and a percentage of what the estate is worth. So if you've got an estate worth £1 million, and a solicitor may charge anything from 1%, and I've heard some horrific cases, anything up to 8%, on £1 million at the top end, you're talking about £80,000 plus VAT plus time. It's probably north of 100 grand to do probate for £1 million estate. Now, there was, in fact, can I have a cloth, please? Thank you. There was a story in the Times recently, and this is a true story, and you can look it up if you want to. This was about an elderly gentleman who didn't have a will, so his son, who was a financial advisor, told his dad to go into town and see a solicitor to get his will sorted out. So here's the gentleman concerned, and he's popped down the town to the solicitors. The solicitors have drafted his will, and the solicitor has made himself the executor. Now, this is the horror story. When this gentleman died, the solicitor, who was the executor, arranged for his mate over here, who had a probate company, to do probate for this gentleman's estate. The gentleman's estate consisted of a house worth in the region of £300,000. The probate company charged £111,000 for valuation and to provide proof about who owned the property and where it should go. That is immoral and shocking, and you don't ever want that to happen. There's another story about when you pick people to be the executors of your will, you want to make sure that they know what they're doing, because otherwise it'll come back and bite you bite your executor in the backside. And let me tell you the story. Here is another said gentleman who owned a property, and the property was worth £450,000. Gentleman unfortunately passed away, and then the executors, who were a family member, and the solicitor, were in charge of arranging probate. Now, this house was empty, and unfortunately there was a fire, which meant the house was completely destroyed. So the executors went to the insurance company, which from memory I believe was the Halifax. They told them the story, and the Halifax said, "Has the house been empty for more than 30 days?" To which the executor said, "Absolutely it has." So the Halifax said, "We have no claim to answer, because the terms of the policy is the house must be inhabited." Who is liable for the £450,000 due to the estate? Let me tell you, if you're an executor, you're liable. So this family member and this solicitor had to find that money to repatriate that to the estate, because that is what they are liable for when you are an executor. Now, there is lots of ways to protect your assets against probate, right? And I'm just going to share a quick solution. And the solution is very, very straightforward. Anything that you put in trust, and this is what your trust looks like, because it's our box, okay? And on the top of the box is our set of instructions, and it says what assets are in the box, and on the side here is a keyhole, right? And then there's a set of keys down here, only available to those that are on top of the box. Any assets that you put in the box are outside of probate. So your main residence, investment properties, life insurance, investments, cash, you name it, anything that goes in the box doesn't have to go through probate, which saves your family a whole load of time, effort and money. All right. Now we're going to talk about another stealth tax that the Inland Revenue have snuck up on everybody. Cloth, please. Right. 2013 Finance Act, right? It's about 1 million pages. You don't want to read it unless you suffer from insomnia. But in the middle of it, HMRC put a little twist so they could claim even more tax. And this is from life insurance. So if you've bought life insurance, the first thing that you need to check that you've got a trust around it. Because if you die, you do not want this lump sum of money coming into your estate, even if you're married, because sooner or later HMRC are going to tax it at 40%. Let's give you the enormity of this. If you've insured yourself for £1 million and you die, there's no trust, and that money comes straight into your estate, potentially £400,000 of that is going straight to HMRC, which probably wasn't the plan when you took the life insurance out. So, point one, make sure that if you've got life insurance, it's got a trust around it. Do not use the trusts from the insurance companies. Your financial advisor, if he's worth his weight in gold, not salt, salt's cheap, gold's expensive. If your financial advisor's gone the extra mile, he'll make sure you've got a proper trust with professional trustees, because you don't want to rely on Aviva or Legal & General or any other of the life companies out there whose trust is not really bespoke for you, and they'll end up paying direct to the estate and causing a tax problem. So make sure that you've got a trust. And the other thing is, your financial advisor might not know this, but if you're buying life cover, you don't want to have any particular policy being valued at more than 250,000. So if you need life insurance of £1 million, you need 4 policies. So what I need you to do is go and have a look in your drawer where you're keeping all your life insurance policies, and have a look. And if you've got no trust document there, or you've got a trust document with the life company, you'll want to get that altered. If the sum assured is more than £250,000, we need to have a look at it, because you don't want your family to be paying unnecessary tax. All right, I'm now going to move on to something called a car crash, which isn't very nice, but it's horrible. Cloth, please. Okay. Another story around intestacy and how things can go very, very wrong if you don't plan accordingly. Now, we have got another lovely couple, and the husband is called Gareth. Gareth's 44 years of age. He's married to the lovely Dawn, and she's 40 years of age. Now, Gareth and Dawn have both been married before. Gareth was married to a lovely lady called Rachel, and Dawn was married to David. Now, he was a bit of a one, okay, shall we say. Gareth and Dawn have a house that's worth 250 grand, and they own it jointly. And they got no wills. Gareth has 2 children from his previous marriage. Tim, who's 12, and Keith, who's 10. Dawn, 2 boys too. So this is a bit like the Brady Bunch. Neil is 10, and Stephen, with a PH, is 8. So you can see the family set up here. Gareth and Dawn, 44, 40, no wills, own their house jointly. You've got the 2 children from Gareth's first marriage with Rachel, and we've got the 2 children here from Dawn's first marriage with David. One Sunday afternoon, Gareth and Dawn take her 2 children out for a ride in the country. Tim and Keith are with their mum. This is never a good story that I'm going to tell, but unfortunately, driving through the country lanes, they have a head-on collision. Gareth, Dawn, Neil and Stephen are all tragically killed. Now, the question I ask you, from the laws of intestacy, who ends up with the home? I'll explain, and this will probably shock you. In the event of a car accident, it's always deemed to be the oldest person in the accident is to have died first. So in this instance, Gareth is 44. He dies, no intestacy, so the first £270,000 of his estate goes to Dawn. All they've got is a house they own jointly. So, by the way, she gets it all. Now, she's 40. She's now inherited the house, but she's passed on. Who's her next of kin? her next of kin is Neil, who's 10. Unfortunately, he's also passed on. His next of kin is his brother, who's Stephen. He's also passed on. The tragedy of this story is that David, Dawn's ex-husband, ends up with the family home. You do not want that to happen to your family. So if you're sitting there like this with no planning, either never go out in your car. If you do, make sure that you've got the right planning in place that says what happens in the event of death. Do not roll this dice and leave it to chance that your ex-partners end up inheriting your estate. All right. I'm now going to cover some what I would call urban myths. Cloth, please. Right, just going to cover off some urban myths that people, I've covered some of it already, don't think this won't apply to you. Common law husband and wife counts for nothing. If you are in a long-term relationship, short-term relationship, and you die, the laws of intestacy will take effect. It means that if you are with a lady or you're with a gent but you're not married and you die, they will get nothing unless you've written a will instructing them to get nothing. So urban myths, common law counts for nothing. Godparents. Just because you have godparents for your children, if you haven't named guardians in your will and you pass away with children under the age of 18, your kids will be taken into care by the state while the state decide the best place for your children to be looked after. That might not necessarily be with your family. That may be care home. That may be foster parents. Think on. So what's important is godparents do not necessarily become guardians. That is a myth. Joint bank accounts. If you lose the ability to make a decision, or you wake up in the morning and you've completely lost your mind, and unfortunately in the UK this year, 1 in 4 people will get a mental illness of some severity, whether it be depression or anxiety. These can lead to people not being able to make decisions for themselves. If that happens to you and you have a joint bank account with your partner and your partner loses mental capacity, your bank account becomes frozen because the person that's lost mental capacity is now classed as a person at risk. And any other investments or property that that person owns is frozen and you can do nothing with it. It creates a massive problem for the person that has mental capacity and who is the other signatory on this bank account, because you can't pay bills, you can't do a whole load of stuff. And you're going to need to trot down to the Office of the Public Guardian. If you want it done for you, it's going to cost you about £4,000 and can take anything from 9 months to a year. There is a simple fix to that, and that is to make sure that you get something called a lasting power of attorney set up. These are not just for old people. You can do these from the age of 18 right the way up to people who have not lost temperamental capacity, are able to make decisions. But once you've lost that ability to make those decisions, to look after yourself physically and mentally, it's too late. And then you have a massive problem. So don't think because you have a joint bank account that will remain open. The bank will freeze it and you won't be able to access it until you get the right paperwork in place. Last urban myth, property ownership. I know lots of people over the years who've diversified their investments into property. That's what a property looks like. Okay, now we've already covered how you can own a property on your own, jointly with a partner, usually husband or wife, and tenants in common. Now, what if you've actually done this as well, where you're down the pub one evening and you decide, you know what, I've got some spare capital and my mate Jeff's got some spare capital. Why don't we start buying some properties together? So guess what? Me and Jeff, we buy a property together and we buy it jointly because we thought that's the thing to do. We're not married, we're not in a relationship, anything like that. We buy it jointly. What happens? If I pass away, Jeff gets 100% of the property. Okay, not the plan. My kids don't get it, Jeff gets to keep it. Now, if you're in business, the next thing I'm going to cover is what you need to have in place should you be in business with someone outside of your family. So watch on. Right. 27 million limited companies in the United Kingdom. If you're in business with someone, you need to know about this. So let's look at two business owners, two gents. One's name's Bill and the other's named Ben. Bill and Ben have got a business making and selling nuts and bolts. Bill is the engineer and Ben is the salesman. So they complement each other perfectly. Bill owns 50% of the company and Ben owns 50% of the company. Looks great, the company does very well and their families enjoy a good lifestyle. And let's just say in this instance that on their balance sheet for the business, the accountant has valued the business, this is just for example, at £1 million. Tragically, one day, Bill has a heart attack and dies. Now this is what happens in the real world. The shares of his business, he owns now 50% of the nuts and bolts company, pass to his wife, Jenny. She now owns 50% of the business. So every Friday she walks down to the factory and says to Ben, can I have Bill's wages? And at the end of the year, can I have half the profits? Now, the problem that we've got is there's twofold here. Is Jenny knows absolutely nothing and knows nothing about nuts and bolts. They've lost Bill, who was the engineer who made everything. So Ben knows nothing about making them. He just knows something about selling. He's now got nothing to sell because there's nobody here to make it. And now he's got half the time he had, half the skill set, and someone draining the profits out of the business who's adding zero value. Now, there is a workaround for this, which I'm now about to show you. Instead of Bill passing away and the shares go straight to Jenny, what if there was something else that you could do that meant that Bill and Ben had a pot of money each, and this instance, let's bring that down here so you can see it. They had a pot of money each of £500,000. Now, I know you're probably sitting there thinking, well, I couldn't leave £500,000 in the business just in the event of me dying, and you're absolutely right, and you'd be crazy to do that. What we would instruct these guys to do in this instance is to effect a life insurance policy for their share of the business. So what's going to happen? The same thing. Bill passes away and the life insurance policy kicks in and that comes into the company. Ben then says to Jenny, Jenny, here's what I'm going to do. I'm going to give you £500,000 for the share of the business that you now own, and then I will own 100% of the business. Right, so now Ben can now go out and find himself an engineer. He's got nobody draining the business of half the profits. He's got Jenny has got £500,000 and everyone's a winner. Obviously, Bill's not, because he's not here. But that is something that if you've got a limited company and you're not in business with your family, you need to have this in place. And what you need in the middle of all of this is a corporate will. You don't have a corporate will that says this, you are going to cause this problem. If you don't have these pots of money in place, you've got a massive problem. So my advice is, as part of us helping you, if you're sitting here looking at this, make a note to talk to us, and now one of our expert estate planning consultants will tell you how to fix it. All right, thanks for that. Now I'm going to cover off how you're going to get the book. Right, so for those of you that are still here, and I hope you've got massive value from what I've told you today, I'm now going to tell you how you get this book. Okay, so you can buy it on Amazon if you want. If you want a hard copy, we'll make sure that you get a link. If you want it for free, there's a process for doing it. Now, you're going to see a 10-question questionnaire that basically covers the stuff that I've spoken about today. So if you are concerned about how you protect your loved ones, how you protect that the family home goes to the right place when you're not here, if you're concerned about how to protect your investments and cash, if you're concerned about who's going to end up with ownership of your business, and if you want to control the amount of inheritance tax and probate that your family may pay, then this is the form that you need to complete. Okay, it's a yes no answer. Complete that, give us your contact details, and then we'll make sure you get this book wired straight to your best email account. On top of that, now this book is 174 pages, okay? You might go, blimey, I don't even know where to start. So what you'll qualify for is a half-hour slot with one of my estate planning consultants who are specialised and trained to help you fill out this book as quickly and as efficiently and make sure that all your planning is in place. On top of that, you also get access to our information vault, which has got lots of videos about some of the stuff that I've covered today and a lot more. All right, so what I need you to do is to fill out the questionnaire, give us your contact details, arrange the slot to talk to one of our consultants to help you fill the book out, and then we're good to go. I hope you've enjoyed it. Thank you very much for listening, and I'll see you soon.